Coming to the Act, after going through them in detail, we are convinced that the Act is absolutely discriminatory, motivated, malafide, undertaken without application of mind, and also an affront on federal governance. It is discriminatory because similar provisions are available in Hindu Endowments Act also, which is sought to be deleted from Waqf Act in 1995. If the provisions are bad for Muslim Waqf, how can they be good for Hindu endowments is the question here. Secondly, they are motivated and malafide because the amendments are sought to are bound to finish off the Waqf institutions in India. They are without application of mind because most of the certain provisions are contradictory to each other. And then they are an affront on federal governance because most of the rule-making powers of state government for Waqf management has been taken away by this amendment. I basically have done a comparative study of Hindu endowments as well as Waqf Act 1995 and other acts. So I want to bring out the discrimination, the unconstitutionality with only 9 to 11 points. We all know that the amendments are 42 and 43 provisions have been amended. Whatever I will highlight, that will very easily bring out how the act is discriminatory, unconstitutional and undemocratic. The problem rises from the beginning of renaming of the act, and each component of this name is based on falsehood and sloganeering. Secondly, this act creates divisions among Muslims. Now, how is that? The provision to separately define Aga Khani Waqf and Bohra Waqf and to have a separate board for them whenever government wishes basically is malified and prima facie meant to create divisions among Muslims. See, the Sunni and Shia Waqfs have been differentiated earlier because both the Waqfs, Sunni and Muslim, were governed by different religious edicts. But then Bohra Waqf and Aga Khani Waqf are governed by Shia edicts only. So creating a new class is nothing but divisive policy of the government. When we look at the powers given to the collector through this amendment, the act is a direct attack on properties of Muslims, and it designs an ingenious way to declare any Waqf property as government property or government institution. And for this purpose, collectors have been roped in for Waqf management. I'll establish it how. The Act provides for reopening of the status of already notified and settled Waqf property where a claim can be raised for that it being a government property. Now, such claim shall be referred to the collector, and if the collector deems fit, he shall conduct an inquiry into that and then determine whether the property is government property or not. Until such determination, that property will be, which was already notified and settled, will be deemed to be government property. Secondly, this act clothes the collector with the role of survey commissioner for all the pending surveys. Thirdly, the act provides that on receipt of an application for registration of any Waqf property, the board has to forward that application to the collector. It means that no registration can take place without the approval of the collector. But when it comes to Hindu endowments, the assistant commissioner under Hindu endowment is competent to register any endowment or endowment property after calling for objections without any role from collector. See how is the discrimination. And then the Act also makes a provision that if a mutawalli do not comply with any direction of the collector, he shall be liable for a punishment of imprisonment up to 6 months and for a fine of 20, not less than 20,000 rupees, but which can be extended up to 1 lakh rupees. So if one reads all these provisions, it looks worse than a farman of British Empire time. And then the provisions are not only draconian, but also are violative of certain settled provisions of law. Like, if a dispute is settled in an existing law, it cannot be reopened in a new law, under a new law. That is a settled position of law. So if a property was settled and notified as a waqf, how can it be reopened again with this new act? Certainly, there's also a settled provision that a person cannot be a judge of his own claim. Now here, the collector is claiming that the waqf property is a government property. He himself, how can the collector himself, when he himself is claiming that certain property is a government property, how can he be the judge of that claim? So this is again against a settled position of law. It is also settled that revenue authorities cannot decide title of a land. Yes, only a civil court has the power to decide the title of the land. Here the collector, who is an executive, is deciding the title of the land. And punishing a mutawalli, imagine punishing a mutawalli just because a mutawalli is not complying with the directions of the collector. No sane person will accept such kind of nonsense, is it not? It may not be out of place to mention that under Hindu endowments, the collector's role is limited only for recovery of revenues on the orders of the endowments commissioner. See how the powers there in Hindu endowments have been limited. The role of the collector itself was limited, and here he has given so much draconian, almost draconian powers. He is in a position to punish or send a mutawalli to jail if he doesn't comply with the orders of him. So, then again, waqf properties are governed by Hindu council or Hindu board. Now, how is that? This act aims at ensuring that eventually waqf property should be managed by Hindus. So, the compulsory induction of 2 Hindu members in the Central Waqf Council as well as Waqf Board is only a first step. Let me tell you, the Central Waqf Council, according to this act, envisages 22 members, out of which 10 members are specified to be from Muslim community. 2 members are supposed to be mandatorily or compulsorily inducted from Hindus. They have to be Hindus. And the remaining 10 are not specified at all. They are not specified whether it is said that they can be either Muslims or non-Muslims. Likewise, similarly, when it comes to Waqf Board, for Waqf Board, the Act envisages 11 members. Out of these 11 members, 4 have to be from Muslim community, 2 have to be Hindus, and remaining 5, including the chairman of Waqf Board, can be either Muslim or non-Muslim. So, specification of making 2 members mandatorily to be Hindus, and then non-specification of the remaining 10 members at Waqf Council, Central Waqf Council, and remaining 5 members at Waqf Board, non-specification of these members whether they are to be Muslims or non-Muslims. It has paved the way, or it has ensured that almost most of the members of the board or the council, the council and board will end up to be ruled or governed by non-Muslims. But when it comes to Hindu endowments, there's no provision which specifies like this about non-Hindu members. In fact, it says that Hindu Endowment says, according to Hindu Endowment Act, the members of Hindu Endowment should be Hindus, and it insists that they should be devout Hindus. Not only Hindus, but devout Hindus. So imagine, see the discrimination, the discrimination between Hindu endowments and Waqf board or Waqf, Central Waqf Council. So, in addition to this, see, generally the trend in a democracy is to move from nomination to election. But this act, the new act provides that the members, the Waqf board members or the Waqf will no more be elected. All of them will be nominated by the government of India. So, generally, the trend in a democracy is to move from election to nomination, and this act provides that it will move from election to nomination. So, any person who has faith in a democracy, such kind of movement from election to nomination will not be acceptable, neither to you nor to me. Then coming to CEO, the act does not get satisfied by changing the composition of the Waqf board or Central Waqf Council. It goes a bit further and tries to make the main functionary of the board, that is CEO also to be a Hindu or a non-Muslim. Now how is that? The act provides that earlier there was a provision that the CEO should be a Muslim. But now the act provides that CEO need not be a Muslim. And then the act also removes the provision of appointment of CEO in consultation with Waqf board. Now the act provides that no consultation of Waqf board is needed to appoint the CEO. His rank has been raised from deputy secretary to joint secretary. Finding a deputy secretary itself has been very difficult in Muslim community. And now raising the rank from deputy secretary to joint secretary will make it almost impossible, and it will end up in including or appointing a non-Muslim as a CEO. Now in total contrast to this, if you look at Hindu endowments, the commissioner of Hindu endowment, the endowments commissioner or assistant commissioner or deputy commissioner, whoever is the functionary, chief functionary there, they will be exercising powers and performing their functions as long as they are professing Hindu religion. The minute they cease to profess Hindu religion, they will no more exercise their power and perform functions in respect of Hindu endowments. See, it's total contrast with Waqf, what they have done. Coming to Limitation Act. Let me tell you then, there's a lot of ha-ha about this. And what is that? Some people, a certain section of society have falsely alleged, and to gratify such section of population, the section 106 has been deleted. Section 106 gave protection to Waqf properties from Limitation Act. Okay, and what is that Limitation Act of India says? We all know that if anybody is in possession of a private property for 12 years or more and nobody claims that property, that possessor will become the owner of the property. Likewise, if it's a government property and if somebody doesn't claim it for more than 20 or 30 years, then the possessor will become the owner of the property. But such limitation was removed. The Waqf properties were given protection. It means the court has come up, once a Waqf is always a Waqf. So how many years ever, if somebody is in possession or encroach that property and is in possession of that property, the Waqf property will remain Waqf property. But what's the problem here is, there's an again a narrative created by government that, among the people, that Waqf properties were given protection from Limitation Act and not Hindu endowments. See, the people might be ignorant, but government is not ignorant. Hindu endowment properties also enjoyed exactly the same protection from Limitation Act as the Waqf properties have enjoyed. Now, after that, coming to Waqf Tribunal, the finality of the decisions of the Waqf Tribunal has been removed by the Act. Now, if a finality of the decisions of a court is removed, what will happen? It will pave the way, or it will help in perpetuating the Waqf disputes, is it not? It will perpetuate the disputes. And then, but then in contrast to this, the Hindu Endowments Tribunal's decision remain final. So, I mean, whatever decision Hindu Endowment Tribunal will take in matters of endowments disputes, that shall be final. This is so much of discrimination has been brought with this amendment. Evacuee property, as my brother has told, that is actually, that here also people are instigated. Lot of instigation is done, where they claim, the government says, the entire Waqf board, the Waqf board has declared large number of enemy properties. I mean, the people who have migrated to Pakistan and left their properties, the Waqf board have grabbed and has declared it as Waqf properties. This is absolutely ridiculous. Let me tell you, a Muslim who has made his property as Waqf and then migrated to Pakistan. So, the same property, if after their migration has been declared or notified in Evacuee Properties Act, the legal position for this problem is very simple. Whatever notification was, either if the Waqf was made earlier or the notification in Evacuee property was made earlier, that will be seen. And whichever was done earlier, that shall prevail is the legal solution for this. But then, lot of hatred, lot of misinformation is spread in the society, and people are really not able to understand. So then again, as Sir has told, I would not say oral Waqf. See, I would just take your attention to this. If oral Waqf is removed, is not allowed according to Waqf property, have they amended Transfer of Property Act? What does the Transfer of Property Act say? Transfer of Property Act says that any Muslim can gift his property orally, and any Muslim or a Hindu can make a will orally. If Transfer of Property Act is empowering a person to make a gift or Waqf a property orally without making any amendment in Transfer of Property Act, how is this government trying to bring an amendment and making that one cannot make an oral gift here? And what about the people who are on deathbed? Imagine the plight. If somebody is on deathbed and who has no access to a scribe, or suppose if somebody has no capacity to sign and makes the oral Waqf of such property on the deathbed, what should be the fate of such properties? Will they all go? And in India, the custom has force of law always, right? So in that case, succession of mutawalliship has been prevalent from time immemorial. So, if oral appointment is not possible, then will all the mutawallis go in one go? What are they trying to do? What will be the status of all these properties? There are so many ancient Waqf properties which cannot produce records or deeds. The government says through this act that all the Waqfs have to produce their deeds, Waqf deeds, within a period of 6 months to the central government. How is that possible? It's so impossible. From where will you get the records of 100-year-old masjid or madrasa? How is that possible? And this question was raised by Honorable Supreme Court also, where our Solicitor General didn't have any answer. So my brothers and sisters from other faiths, my fellow citizens, I just try to make very brief and try to highlight how discriminatory this act is, how unconstitutional this act is. Unconstitutional because it is violating Article 19, Article 21, Article 300A, Article 25, Article 26. Today, if we think, if our fellow citizens make up a mind, okay, this is an issue, Muslim issue, and just keep quiet. Please understand, we are trying to normalize in this country that the government can make unconstitutional law or undemocratic laws. If we keep quiet, we will empower the government. Today it's BJP, tomorrow it might be somebody. But if we are awake, if we are not awake now, if we don't wake up now, and if we don't raise our voice, please understand that things will become, such unconstitutional laws will become very normal tomorrow. See how UAPA is being used against us. This will happen with everyone.